the update in the Tyler Robinson hearing that occurred last week. Tyler Robinson's defense attorneys, I covered a bit of the highlights last week. Just want to keep everybody up to speed on it because it's an interesting case, and they had better make sure that trial remains public when it goes to trial. There was hold on one second. Hold up. Wait a minute. Where's the link? Come on. Department of State, Canada, that's the students one. Oh, Charlie Kirk, here we go. So last week they were having a motion to disqualify the prosecution office, the Utah prosecution office, because the daughter of one of the prosecutors was at the event, but didn't see the shooting, didn't see the actual moment. And defense attorneys doing what defense attorneys do, which is, use every avenue of procedure and substantive and procedural law to try to frustrate the prosecution's ability to secure a conviction. They say, I want the entire Utah prosecution office out of this. They had asked that it be referred to the Attorney General's office so they can appoint someone else because the Utah prosecution office was so conflicted they couldn't even argue against their own disqualification. The judge said, no, they can. During that hearing, they wanted to preclude the video of Charlie Kirk being murdered from the evidence because they, said it would be so prejudicial, not from the trial. So this is the distinction that people have to appreciate. Just from the hearing on the motion to disqualify, they did not want the video to be played. And from my understanding of what occurred, the video was not played during that debate on the disqualification. It does not mean that the video is not going to be played during the trial, which I think some outlets might have misunderstood. And it would be inconceivable that they're going to have a trial and not be able to show the primary piece of evidence of the murder. Now, the argument during the motion to disqualify was the defense is saying, we don't deny that it happened. We're just denying, obviously, that our guy did it, and they'll do that at the trial. But we're just arguing that the prosecution's office is conflicted. There's no need to play the video. It's going to inflame everyone's passions to the point where they're going to be more inclined to refuse the disqualification. And The Guardian is reporting this. When is this from? February 3rd. So it's a little old, but lawyers for accused Tyler Robinson urge removal because the prosecutor's daughter attended the rally where Kirk was killed. Robinson's attorneys argued that a judge should disqualify local prosecutors because the adult daughter of Chad Grunander, a deputy county attorney, was in attendance at the rally. Grunander said his daughter testified before the judge, Utah, on Tuesday. Grunander told the court that his daughter's presence did not play into the office to seek the death penalty. So that's the repetitive part. The judge is going to issue the ruling towards the end of February. So the confusion was not that they're not going to show the video at trial. They argued not to show the video on the hearing of the motion to disqualify. They didn't show it under deliberation, or the judge is going to issue a oral ruling followed by a written ruling. And I'm going to make my prediction. They're not going to get disqualified. They'll have tried to, I don't know, I want to say poison the well. They tried to get out some evidence during this hearing, and it's the clip that I played last week, which was the defense attorney asking a question which was totally loaded, putting into evidence, or I say putting out into the public domain information which was not in evidence, and there was no objection to it, which I found problematic, about there being a mixture of DNA at the scene of the crime, which I hadn't heard was the case, and apparently it wasn't the case. And just to refresh everybody's memory so it's complete with this presentation, this was the ruling. This was the question right here. Let's listen to this and appreciate what the defense attorney is doing, which is loading a question with I'll put it as a fact, which is not in evidence yet. Evidence in the legal trial sense. Loading the question with it, baking the question with it, knowing that it's going to get to the public's ears and possibly taint a jury pool who are now going to, for some reason, believe that there were 5 people's DNA mixed in with the DNA at the scene that implicated Tyler Robinson. Listen.
And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA.
I'm not aware of that, no.
Okay. And you,
I'm not aware of that implies that that is a fact. That is a bullshit question that demanded an objection that didn't come. And now that soundbite, that piece of information, oh, there's 5 people's DNA. Well, now I've got reasonable doubt as to who was on the roof that shot Charlie Kirk.